This is Torts, essay statements of law for the bar exam. Negligence. A prima facie case of negligence requires a plaintiff to prove duty, breach, actual, and proximate causation, and damages. In general, a defendant breaches the duty to a plaintiff if they fail to conduct themselves as a reasonable person would in the same circumstances. The reasonable person standard is applied as though the reasonable person possessed the same physical characteristics as the defendant. The reasonable person standard also specifically takes account of age when the defendant is a minor. In the majority of jurisdictions, a minor defendant's conduct is assessed according to what a reasonable child of the same age, education, intelligence, and experience would have done. A minority of states follow the traditional rule under which a child who is age 6 and below was conclusively presumed incapable of being negligent. Business invitee. A business invitee is an invitee who enters onto the defendant's land for a purpose related to the defendant's business activities or interests. A defendant has a duty to exercise reasonable care to prevent injuries to invitees caused by activities conducted on their land. The defendant also has a duty to exercise reasonable care to discover dangerous artificial conditions that invitees would not reasonably be aware of, and to warn invitees of the existence of such conditions, or to make the conditions safe. A defendant has no general duty to take affirmative action to aid a plaintiff where the defendant did not create the risk of harm to plaintiff. However, when a defendant undertakes to render services to a plaintiff and knows or should know that the services will reduce the risk of physical harm to the plaintiff, the defendant will have a duty of reasonable care to the plaintiff in conducting an undertaking if the failure to exercise such care increases the risk of harm beyond that which existed without the undertaking. Intervening forces. An intervening force is one that actively operates in producing harm to another after the actor has already committed his negligent act or omission. As a general rule, a defendant will be held liable for harm caused by foreseeable intervening forces. Because rescuers are always foreseeable, the original tortfeasors will be held liable for the ordinary negligence of the rescuer. Where two or more defendants acting in concert injure the plaintiff, or where two or more defendants acting independently injure the plaintiff, and the resulting damages cannot be allocated to particular defendants, all of the defendants are liable for the entirety of the plaintiff's injury. The plaintiff may execute against each defendant for the total damages suffered, although the plaintiff may only recover from any or all defendants an amount equal to the total damages awarded. Wow, sorry about the cough here. Alright. Another negligence statement. A prima facie case of negligence requires a plaintiff to establish duty, breach, causation, both in fact and proximate, as well as damages. In general, defendant breaches the duty of plaintiff if he fails to conduct himself as a reasonable person would in the same circumstances. An actor may be found to have breached the standard of care if the actor violates a statute that is designed to protect against the type of accident the actor's conduct causes, and if the accident victim is within the class of persons the statute is designed to protect. However, compliance with a statute is regarded as mere evidence on the issue of whether a defendant breached his duty of care, and does not raise any presumption in the defendant's favor. Medical malpractice after the fact. As a general rule, a defendant will be held liable for harm caused by foreseeable intervening forces. This usually includes diseases contracted or subsequent injuries sustained because of the impairment of the plaintiff's health resulting from the original injury caused by the defendant's tortious conduct. Subsequent medical malpractice is within the scope of the risk created by a tort defendant. Res ipsa loquitur. Res ipsa loquitur is a means of adducing evidence of breach of duty. The doctrine permits the jury to infer the defendant's breach of duty in most jurisdictions. A plaintiff must establish that three prerequisites are present in order to invoke the doctrine of res ipsa loquitur. 1. The event that caused the plaintiff's injury was one which would not ordinarily occur in the absence of negligence. 2. It is more likely than not that it was the defendant's negligence that was responsible for the injury-causing event. And 3. The plaintiff was not responsible for the event that caused the injury. Damage apportionment. Where two or more defendants acting in concert injure the plaintiff, or where two or more defendants acting independently injure the plaintiff, and the resulting damages cannot be allocated to particular defendants, all of the defendants are liable for the entirety of the plaintiff's injury. The plaintiff can execute against each defendant for the total damages suffered, although the plaintiff may only recover from any or all defendants an amount equal to the total damages awarded. Abnormally dangerous activities. A judge determines whether an activity is abnormally dangerous by considering whether the activity 1. Creates a risk of serious injury as to the plaintiff, their land, or their chattels. 2. This risk cannot be eliminated by the exercise of due care. And 3. The activity is not usually conducted in that area. Courts are divided as to whether legal fireworks displays constitute abnormally dangerous activities to strict liability. Foreseeable plaintiffs. Proximate cause. A defendant owes a duty of reasonable care only to foreseeable plaintiffs. Foreseeable plaintiffs are those individuals who are within the risk of harm created by the defendant's unreasonable conduct. This means that under the circumstances, a reasonable defendant would have foreseen a risk of harm to the plaintiff. An unforeseeable intervening force can relieve a defendant of liability, but a defendant will be held liable for harm caused by foreseeable intervening forces. Courts have held that rescuers are foreseeable. A negligent defendant owes an independent duty of care to a rescuer and will be liable for both personal injury and property damage, whether to the rescuer himself, the person rescued, or a stranger. Vicarious liability. A defendant generally is not liable for torts committed by someone he has engaged as an independent contractor, because the defendant has no right to control the activity of the contractor. One exception to this rule is when a contractor engages in inherently dangerous activities, defined as activities to which there is a high degree of risk in relation to the particular surroundings, recognizable in advance and requiring special precautions. Independent contractor versus employee. An agent employed by a principal to perform a service can either be an employee or an independent contractor. If the employer has a right to control the conduct of the agent during the performance of the service, the agent is an employee. If not, the employee is an independent contractor. Factors to consider in determining whether a right to control exists are 1. Whether the agent is paid by the job or by the hour. 2. The duration of the relationship. 3. Who supplies the tools required for the agent's work. 4. The skill required in the agent's occupation. And 5. Whether the work is part of the principal's regular business. Employers are liable for torts committed by employees acting within the scope of employment, but not for torts committed by independent contractors. Respondeat superior. An employer is liable for the tortious acts of its employees if these acts were performed within the scope of the employee's employment. An employee's conduct is within the scope of the employment if 1. It is the kind that the employee is employed to perform. 2. It occurs substantially within the authorized time and space limits. And 3. It is motivated at least in part by a purpose to serve the employer. An employer will not be liable if the employee has substantially deviated from the authorized route, a frolic, but will be liable for the deviation if slight, a detour. Negligence per se, a violation of statute. Negligence occurs when a defendant owes the plaintiff a duty of reasonable care and breaches that duty by engaging in unreasonable conduct causing the plaintiff harm. An unexcused violation of a statute conclusively establishes that the defendant breached his duty to the plaintiff. The injury caused by the defendant's conduct must be the type that the statute was intended to prevent, and the plaintiff must be a member of the class intended to be protected by the statute. Indemnification. An indemnity claim is a claim that shifts all the defendant's liability to a new party. Indemnification is available to a tort defendant who has paid the plaintiff's damage award when, as between the paying and non-paying defendants, the paying defendant was not at fault in causing the plaintiff's injuries, and the non-paying defendant was at fault. False imprisonment. False imprisonment is an intentional act that causes a plaintiff to be confined or restrained to a bounded area against the plaintiff's will, and the plaintiff knows of the confinement or is injured thereby. In general, the plaintiff must be aware of the confinement or must suffer actual harm as a result of the confinement. The defendant has the requisite intent for false imprisonment if he 1. Desires to confine or restrain the plaintiff to a bounded area, or 2. Knows that such confinement is virtually certain to occur. The plaintiff may be confined by the use of physical barriers, by failing to release the plaintiff where the defendant has a legal duty to do so, or by the invalid assertion of legal authority. No duration of confinement is required. A brief confinement suffices. Emotional distress recovery. The issue is whether a jury could properly find that the defendant is entitled to, or that plaintiff is entitled to recover for their emotional distress. In order to recover in tort, a plaintiff must show that the defendant's conduct fell below the applicable standard of care and that the defendant's conduct was both the cause in fact and the proximate cause of the injury. In a claim for emotional distress, a plaintiff must make a showing of a direct claim or that they qualify as a bystander. A plaintiff who is within the zone of danger created by the defendant and who suffers a physical manifestation of emotional distress occasioned by a threatened injury may recover in virtually all states, and some jurisdictions permit recovery if the plaintiff was closely related to the victim, was located near the scene of the accident, and suffered shock resulting from, quote, the sensory and contemporaneous observances of the accident. Failure to take action. The relevant rule is that in any negligence action, a plaintiff must show the defendant owed the plaintiff a duty to conform his conduct to a standard necessary to avoid an unreasonable risk of harm to others, that the defendant's conduct fell below the applicable standard of care, and that the defendant's conduct was both the cause in fact and the proximate cause of the plaintiff's injuries. The defendant has a duty to take affirmative action to benefit the plaintiff where a special relationship exists between the defendant and plaintiff from which the defendant derives, or as to which the defendant occupies, a position of power over the plaintiff. Business patrons have been generally recognized as triggering the duty of care for the plaintiff. Where a defendant permits a third person to use his personal property, the defendant has a duty to control such use and to exercise due care in permitting the third person to use the property. Under the doctrine of respondent superior, the employer is liable for the negligent conduct of an employee acting within the scope of his employment. Assault and battery are not covered. They could be. Assault is the imminent apprehension of bodily harm, and battery is the actual physical contact causing the harm. This concludes torts.